SJC-10444, Birchall versus Cummins.
Good morning, Mr. Cohen.
Good morning, Madam Chief Justice, Justices. May it please the Court, my name is Richard Cohen. I represent Mr. Richard Birchall. Mr. Birchall has been held in confinement going on 26 months based on one single order of May 8, 2007. That order found, or rather determined, that it inferred an ability to pay.
Could I ask you a factual question about that, though? There were two decisions on May 8th, I believe.
That's right.
One of which was under Section 19 of the statute and found that he had acted fraudulently, correct? That's right. So is any part of the 2-year period of, or the 26-month period of time a year under Section 19?
The limit under Section 19 is 1 year, but the Court specifically on the order of May 8th sentenced him to 30 days. He had already served some 9 days of which, so that the remaining 30 days were already served. So it's long past.
So that was, okay, so most of this 26 months is the civil contempt?
Virtually all of it, Justice Botsford. The reason that we say that the order under which he's held, and it's the only order under which he's held, my sister acknowledges in her own brief at paragraph 12 that this was the basis of the civil confinement. But the only reason that he was held is that the Court determined on May 5th that it had drawn an inferred portrait. Doesn't have a finding. There were no findings. But more fundamentally, there was no notice and no hearing. The supplementary process proceedings continued continuously until May and through May 7th.
No notice of what? I'm sorry, no notice of what? That he owed the money? He owed the money. He didn't pay. He was arrested and brought into court because he refused to come in for the supplementary process proceeding.
He was brought into court. The liability that he incurred was a default liability. The same
wasn't appealed. I mean,
that's correct.
So it's there. He didn't pay, and he knew he didn't pay, and he was brought into a court on an arrest warrant, and there was a 9-day evidentiary hearing about whether he had the ability to pay.
The line between the sections of Chapter 224, which is a very rational statute, the early sections of Chapter 224 provide for locating a witness, bringing him in, having a hearing. The enforcement section, Section 18, requires notice and a hearing, a separate notice and a hearing. There couldn't have been a notice and a hearing for Mr. Birchall because the supplementary process ended on May 7th. His orders were entered and docketed. The judge's orders were docketed on May 8th. There was no separate docket event located in our appendix.
Where is the burden of proof here?
Excuse me?
Where is the burden of proof? Who has the burden of proof?
The burden of proof under Section 16 is exclusively on the creditor. The creditor introduced no race, no evidence of race, no evidence of an ability to pay. In fact, the judge...
No evidence of what? No evidence of, I'm sorry.
Excuse me?
No evidence of race?
The thing.
Yeah,
the thing
race.
Which would be liquidated.
But wasn't there some evidence about hundreds of telephone calls that
yes, there were.
he made that suggested that he was moving his assets around and trying to hide them? Yeah. Wasn't that evidence?
In 2 years, none of that evidence, some 3,000 emails, some 2,500 telephone calls, the entire contents of his home and office, his hard drive, his wallet, everything was taken from him. And in
after he tried to hide it, eventually it was taken from him.
It was taken from him initially, early on in the 2-year period.
Early on in the 2-year period, and actually $1.5 million was collected, even though at his hearing in May he said he had nothing.
It was collected because he, partially because he notified the court in July of 2007 that he had an affiliated account. He identified it. 2 months later, it was taken. That still leaves $1,300,000 that there's no evidence that he has an ability to pay.
Well, wait a minute. He received $2 million+ of Mrs. Demore's money
in 1990
as a lawyer,
yes,
in a fiduciary capacity, had an obligation to account for it. He hasn't accounted for it. There's an inference that he still has it.
That may be an inference, but
That's all you need.
An inference.
And he hasn't explained where the money is. He hasn't said he spent it, he went out and gambled. He hasn't said any of those things.
There's no character or morality test for Chapter 224. Neither of these parties would win a personality contest.
No. There's an inference that he still has the money. That he received as a fiduciary and never accounted for.
The only money that he was found to have received was the amount under Section 19, which said that Birchall had received some $67,000 in the years 1998, the years 2001 to 2003. There's no evidence of actual race beyond that.
But Mr. Cohen, you don't dispute, do you, that back in whatever year it was, 93? I don't know, that Mrs. Demores gave him this money to hold. Do you dispute that?
We don't dispute that at all.
So he had the money.
It doesn't mean he had the money in 2007.
No, but Judge Despina's point is he hasn't said what he did with the money.
Mr. Birchall has neglected to respond. Think of it as an extended demurrer. While it wouldn't be our style to do that, Mr. Birchall has neglected to respond to the Board of Bar Overseers petition, which this court granted. He neglected to respond in the Barnstable Superior Court, whereupon a default judgment was entered against him there as well. Mr. Birchall, for reasons known to Mr. Birchall, wants the creditor to prove rather than him having to disprove. And if you think about it, it would be impossible to disprove or to prove a negative. Every time that Mr. Birchall has addressed a particular referenced source of assets and shown that there's no assets there, the creditor's response has been, well, if it's not there, he must have hidden it someplace else.
Yeah, but has he submitted to a deposition pursuant to the examination here? He was asked to be deposed pursuant to an examination, and did he? And I gather he did not show up. Is that correct?
That's correct.
And has he since shown up?
He has not.
And can't he be held in contempt just for failing to show up? I mean, isn't he obliged to show up?
That's a different kind of contempt, because that's a contumacy directly upon a court. There are two kinds of contempt, as we know.
I'm confused, though. Eventually, he was brought to court. There was a 9-day hearing. He didn't testify at that hearing?
He did testify.
I thought he testified for 5 days or something.
On and off, there were other witnesses. Okay. But there was still no race identified as to where a contempt order could fall. Now, in order to require a contempt...
Was he ever asked what did he do with the money that he received?
He said to the extent he answered the Board of Bar Overseers that he used funds for Mrs. Demore's criminal defense. She was indicted for murder and conspiracy to commit murder and was ultimately convicted and sentenced to 10 to 12 years for conspiracy, the longest sentence for perjury in the history of the Commonwealth. He says that he expended it on her defense, and at the same time he expended it because he was in indirect relationship to her children, was spending money on her children. He does not specify exactly where this money went.
And did he have canceled checks? I assume
No.
So he had $2 million in a bag somewhere and he was doling it out?
The Board of Bar Overseers found that he had deposited it into several accounts. The accounts then had been used, and he was petitioned for administrative discipline and finally disbarment for failing to account for those funds.
So what did he testify to at the 9-day hearing here? You've talked about what the Board of Bar Overseers found, but here he actually testified. Was he asked here the question, what did you do with this money?
The testimony that he gave was scant.
Was what? I'm sorry?
Scant.
Because he wasn't asked or because he didn't answer?
Because he either didn't answer or that's correct.
Asserted the privilege. He actually asserted the privilege, as I recall.
But that's correct. He did assert a privilege. I think it's...
And that was one of the inferences, obviously, that the court said
I think an equal inference the court could have drawn was that Mr. Birchall is inferred to have an ability to pay based on the debris left over from a legal career, left over from a money management career. That's what this is. And the appendix that the appellee has filed contains more of that debris. In 2 years, based on thousands of emails, thousands of mail, pieces of telephone conversations, no evidence whatsoever.
Well, doesn't he run the risk that we'll conclude that it's a reasonable inference that he has either knowledge of where these assets are or control of the assets?
Let's assume that's an inference that you draw. The statute, Chapter 224, and the cases which relate to it do not make inference sufficient. It requires a finding, a relationship between the act that the contemnor is alleged to have to do to bend to the coercive civil contempt, which we don't disagree with. There is such a thing as coercive civil contempt. In all the cases cited by my sister, the Gompers case, the Chadwick case, all require some specific identification. Now, the cases that she cites, like Shilatani or Chadwick, the extracts are artificial. The real citations have to do with the identification. For instance, in Chadwick, Judge Alito in the Third Circuit in Pennsylvania in 1994 says there must be some identifiable act.
Yeah. If, just for the sake of argument, if there were sufficient identification, is there any limit on the amount of time? Do you say that there's any limit on the amount of time that a person can be held in contempt?
No limit at all. And insofar as a specific race that could be identified, Mr. Birchall voluntarily provided to the appellee an unlimited, unqualified assignment of any property anywhere. My sister has actually gone down to the Bahamas, has had access to any number of investigative bodies, no race, nothing. And the fundamental unfairness here is that Mr. Birchall sits in jail based on an order from 2007 that identifies nothing. It says it's an inferred portrait. The order under Section 19, in fact, says we're going to find that you converted and defrauded the plaintiff based on the Board of Bar Overseers petition. That was the only finding, fact finding in this case. The 2001
well, but the court. I mean, I'm looking at the May 8th, 2007 finding, not the one finding him to have engaged in civil fraud, but the one finding that he. Well, let me just read it. The court determines by a preponderance of the evidence that the defendant has an ability to pay the judgment against him in full or impartial payments. I mean, that's a finding.
How is that a finding, Justice Cordy?
Well, it's the ultimate finding, that he has the ability to pay.
The ultimate finding is also based on the judge's statement that says this court need not find as a fact. In fact,
he relies on the fact that $2 million was given to him by the plaintiff here.
Yes, those are
that other funds were given to him by other individuals. Yes. I mean, he relies on lots of information.
The information comes from the petition. In 1994, some 15 years ago, Mrs. Damore gave him $2 million, the proceeds of her husband's life insurance policy, in order to have them secreted. Neither of these people stand completely unalloyed.
Did he produce either a check register or canceled checks at the supplementary process hearing to show that he had made payments out of the $2 million to a defense lawyer or to children of Suzanne Damore? Or?
It's not clear that he made any nearly equivalent showing. But the test for this is, under the statute, still reliant on the creditor's burden, not the debtor's burden. Theoretically, the debtor could say, I demur, and I want you to prove it. There's unimaginably large amount of evidence, and the evidence that is contained in my sister's appendix is still more of the same.
Could I ask you a question about that? There was some talk in the briefs about 2 offshore bank accounts. I can't remember. One was in the Bahamas, I think. Maybe one was in Switzerland. Yeah. Could you tell me about those? Do we know, is there any money in there?
There are no monies in there. The Bahamian account was described in the Board of Bar Overseers petition, and it was exhausted.
How about the Swiss account?
The money was put into a fund which Mr. Birchall controlled in the middle 90s, late 90s. And as to those funds, Mr. Birchall presumably would testify that they were exhausted.
We have to rely on him to tell us that?
No. We have thousands of records, emails, including bank statements, which the 2 deputy sheriffs went to his home and office, took the place apart, and found many of these accounts all showing 0.
And the same for the Switzerland account?
Same. Well, the Swiss account was depleted after Mr. Birchall noticed the court in July of '07 as to the existence of the affiliated account, and then the plaintiff took it.
Mr. Cohen, if we were to disagree with you, and if we were to say, for example, that no, the burden in this particular case, because he was an attorney for Suzanne Dumour, he really does have a responsibility to prove where the money went. If we were to say that, has he ever claimed that I have no more files left, or my files have been taken, is there any claim here that the documentation does not exist?
Well, first, the premise is somewhat disputable because the statute requires the exact opposite.
Yeah, just for the sake of argument, let's say we don't go with you on that. Is he saying it's impossible to prove where the money went?
No.
Okay.
No, he's not saying that.
Okay.
In fact, he did not have access before this May 8th order, which was without notice and without a hearing. The rule should be that when a debtor is in a court where there's liberty threatened, then it triggers the due process requirement of notice and a hearing. And there's good reason for it, because otherwise he sits in a debtor's prison and he's got a life sentence. Now, that's why we need the superintendency of the court, if only to say, in accordance with the cases like Crystal, like Payson, the Supreme Court cases which my sister cites, if only to say that there needs to be some identification. From 15 years ago, it's conceivable that the money could have been expended. No finding has been made of where such funds are. Mr. Birchall is not being coy in asking that the creditor bear this burden.
Thank you.
You're welcome.
Justice Gans, do you have a question?
No. Thank you, Mr. Cohen. Good morning, Ms. Vecchi.
Good morning, Your Honors. My name is Jennifer Vecchi, and I represent the intervener, appellee Suzanne Dumour. Your Honors, this case actually presents not only of a case of a judgment debtor defying the power of the court to enforce a judgment, but it also ultimately presents a challenge to the inherent power of the courts in Massachusetts to enforce their orders and judgments.
Was there a subpoena issued on Mr. Birchall to produce his check register and any canceled checks?
Yes, Your Honor, that would have been in the underlying action. That was in the Superior Court action.
No, here, in this particular case.
Not at the onset, because...
Ever?
Well, no.
Forget the onset.
Well, Your Honor, the reason why is that the judgment's already been rendered in the lower court, and that's where the evidence was presented. This action is strictly enforcement of the judgment. They're not permitted to look behind the judgment.
Miss, if that's the case, if it's strictly to enforce the judgment, you're not looking behind the judgment, you're not looking at any relationship between the debtor and the creditor, fiduciary or otherwise, where does the burden lie? To show that there is something, a lease, a bank account, a motorboat, whatever it is.
Your Honor, that lies on the creditor. And, Your Honor, that is precisely what occurred in this case. There was, Your Honor, 33 exhibits. There was 9 days of testimony. 6 witnesses. Mr. Birchall was on the stand for 5 days. There was a plethora of banking records, including bank accounts in the name of various entities such as BH Partners at Cape Cod Bank and Trust Company.
And what did those establish?
What they established, Your Honor, is what you would see is you would see wire transfer deposits coming into the bank accounts from foreign countries and foreign banks, such as Credit Suisse in the Bahamas.
Yes, I understand that, but you
and
can...
then you have the checks where Mr. Birchall dissipated that money. He took it for his own benefit.
Yeah, I understand that, but the proceeding here is, does he have something, some asset, some money, some funds, some bank account from which he can satisfy the judgment?
Yes, Your Honor. And you need to understand that this is a fraud case. Mr. Birchall's not forthcoming on anything.
But the fraud part is gone.
The fraud part is...
Actually, the fraud part is an offshoot of this. It happened all simultaneously. The hearing went simultaneously.
I understand that, but that has a criminal sentence. He was given 30 days.
But you cannot overlook, Justice Botsford, the finding of fraud.
Yeah, but he was punished, as I understand it, for that determination of fraud. Now you're into a different section of the statute, and the burden rests firmly with your client. And you can, perhaps the judge should have given a 5-year sentence for fraud or whatever he wanted to do, but if you haven't established that there is some asset...
But we did, Your Honor, and that's what the findings demonstrate.
But it's not a finding.
You said it was dissipated, that what the bank account shows that it was...
What was demonstrated in part was that the money was coming in as recently as January of 2007 from an account located in Zurich, Switzerland.
And can you get an attachment on that account?
We've already collected that account. And Mr. Birchall's position at that hearing was that he had never heard and never had an account at Bank Julius Baer.
Okay, that was the 1.5 million or whatever?
Yes, Your Honor. And essentially, that account was not revealed to us by Mr. Birchall at the hearing.
No, I understand.
He was trying to conceal it. And this is where the equity comes in the sense that this is an equitable remedy. The legislature has placed the responsibility of administrating this particular statute with the district court judge. He has the opportunity to evaluate the credibility, to weigh the evidence, and certainly to make reasonable inferences based upon the evidence.
Let me ask you this, Ms. Becky. One of the judge's paragraphs, I don't know whether it's a finding, says, Mr. Birchall offered no explanation. This is in the section, it's the non-fraud one, let me put it that way. He offered no explanation as to the whereabouts of any of the money he had received from your client or other sources, except for references to the defense costs. If the burden rested with you, why was he required to do that in this proceeding as opposed to, for example, in the Board of Bar Overseers proceeding?
Well, Your Honor, he offered nothing contrary to the evidence that was presented.
No, I understand. So you established that there was this bank account in Zurich, and the judge said, go get the bank account.
Well, it's not quite that simple, Your Honor, because on our end, on the state side, you don't know the number on the account. You don't know the name of the entity. You are blank on this side, and you're requiring this particular debtor to tell the truth.
Well,
that is a very loose...
He was under oath, and presumably, if he refused to answer questions, the judge can draw an inference that, in fact, he's hiding assets. I mean, isn't that right?
Certainly, Your Honor. And that's...
You can meet your burden that way. You've established that lots of money has come through his hands.
Yes. And, Your Honor, the money was coming through his hands through various accounts. He was, at the time, in January of 2007, which were the statements that we had at the time of this hearing, he had opened up an account in Florida where he was wiring the money from Zurich, Switzerland, into that Florida account, which we happened to come across by sheer chance because he passed a check at a local car rental company, and we were able to subpoena it. We are constantly hunting. This is a complete manipulation and complete subversive activities of Mr. Birchall, all to defeat the court from enforcing the judgment.
Could I ask you a practical question? could you show me where is the original contempt? What we have is a memorandum in order saying that he has the ability to pay.
Okay.
And that's, but where is the original contempt?
Your Honor, it's well, this is how April 19th of 2007, there was the original minimus. That's the order that we're looking at. That's where this word contempt arises from. And, Your Honor, in my appendix...
Sorry, hold on 1 second.
Where is that?
67.
67
Page 67 of my appendix.
Okay.
Where's your, what was the date of the order?
April 19th of 2007.
So that, how can that be a contempt on not paying this judgment of May 8th?
Your Honor, what the court needs to understand is that when Mr. Birchall failed to appear at his examination on February 1st of 07,
right.
He was picked up after sunset on a special capias.
Right, I saw that.
Okay. His failure to appear constituted a contempt of court under Section 14 of the statute.
Okay, but that's contempt for not appearing.
However, what the court did is the court sanctioned him. The court could have certainly imposed a sentence on him, could have punished him. The court instead chose to sanction him with imposing statutory bail upon him, which is pursuant to the second paragraph of 224 Section 18. That bail, Your Honor, has continued throughout this entire proceeding. He has essentially been held on bail. Just by chance, the statute reads that the bail is the amount of the judgment.
So excuse me. I understand he's being held on bail. In other words, he can get out
Correct.
if he posts the amount.
Correct.
But are you suggesting that he's not being held in contempt month to month?
Well, Your Honor, that is...
Your motion for contempt was denied.
No, then there's a later one, but it says there's a later one, but it says this is further contempt. I would think there needs to be a contempt based on his not paying the May 8th judgment, and I just don't see one.
Okay. Your Honor, this statute is the legislative equivalent of a contempt proceeding. It has notice, it has service of process, and opportunity for everyone to be heard.
What do you say, what do you say about Mr. Cohen's point that with respect to the Section 18 enforcement piece of the statute, there was no notice and no hearing?
Your Honor, he was certainly provided with notice. He was served with the summons and complaint in this action. The ultimate question in this case, after he was served with the execution and refused to pay it, he was served with the summons and complaint. How much more notice would this former member of the bar need to understand that Mr. Moore is seeking to enforce the judgment judicially in a supplementary proceeding?
So if he's being held on bail, that's not reviewable except under 211 Section 3.
No, it's reviewable, Your Honor. It's reviewable by the actual presiding judge, Judge Williams, at the present time.
No, it's reviewable under 211 Section 3, isn't it?
No, I would say it is not, Your Honor.
No, not Judge Williams. We're talking about this court.
I understand that. Your Honor.
So you're saying that there's no review by this court?
Well, Your Honor, this is a habeas corpus petition. That was my understanding, what was reserved and reported.
Began as a habeas corpus petition. There was also a petition under 211.3, and he has not pursued his habeas corpus petition.
My understanding of the original petition that was filed is that it was a habeas corpus petition. And I would say, Your Honor, that under the habeas corpus statute, which is 248 Section 1, that there does provide for a bail review, but I don't believe that he's asked for a bail review. He is asking to be released without complying with the order of the court.
Which order of the court?
Judge Williams' order of the court, which is to pay the judgment.
But he was held in contempt before the judgment entered.
Your Honor, the order, the contempt comes from the minimus. What happened, Your Honor, is that he made written findings, which, Your Honor, is reflected in the May 8th payment order, which I have identified in my appendix on page 81. Simultaneously, and this is the way it works in the district court, is also an order is issued to incarcerate Mr. Birchall, and that's, Your Honor, reflected on page 84 of my appendix. It's the minimus that brings the word contempt. That's where this arises from.
No,
But the court had...
That can't be right. I mean, he obviously in some form has been held in contempt. If you look at the court's ruling issued August 13th, 2008, the court says the court will continue to hold regular hearings to determine whether Birchall is prepared to purge himself of the contempt found.
Correct. I'm referencing that day of May 8th that everyone seems to be focusing on. But however, on May 8th, the only place where contempt is mentioned is in that minimus as of that day.
Okay, so
exactly. And so this is my problem. May 8th, the court finds you are able to pay and you are ordered to pay. He also happens to be sentenced to jail for 30 days for civil fraud. That sentence is up May 18th, as it turns out, because he's given time served. He's brought back into court on May 16th, according to the docket. Was it at that point that he was essentially asked whether he was going to pay this or not? What happened on May 16th?
It was actually May 15th.
All right, the docket says the 16th, but I know your brief says the 15th.
It did happen the 15th.
Okay.
And the judge asked him if he had paid the judgment. Essentially, this is from memory because I do not have a transcript of it. And Mr. Birchall gave a dissertation on, different reasons why. He basically was arguing with his findings. And the case was scheduled for the following week, essentially, for a review. And that's what the court has done. It's a review. He made the finding. He had the ability to pay it. That is not a separate and apart finding from the fraud. And if you go to the fraud section of the statutory scheme, it actually says in there, in the instance if Mr. Birchall had appealed that fraud finding, that if he had appealed, and as a condition of prosecuting an appeal, that if he lost, if the debtor loses, they are required to surrender on execution and obey the order of the court or pay the judgment. The finding of fraud in this case, Your Honor, is consistent and actually dictates that he has the ability to pay this judgment. They're so consistent.
How much money, if you know, approximately, was paid to defense counsel for Suzanne DeMoore, and how much was paid by Mr. Birchall to the children of Suzanne DeMoore?
Well, Your Honor, I can only reflect it from the Superior Court Assessment of Damages hearing, because there was an actual trial on the issue of damages where Mr. Birchall appeared and defended. And in that case, I believe there is a written finding by the court, and from memory, I would say that it was approximately $300,000 regarding the defense costs. The court took into consideration sales of property, X, Y, and Z, but the interest on the principal amount of the money that was given to him was never taken into consideration. Mr. Birchall cross-examined Ms. DeMoore in the Superior Court, and he did not appeal the amount of the judgment. It was 2.7.
But the judge reduced the total amount owing by an amount...
By amounts that my client testified to were absolutely legitimate deductions from the $3.3 million that Mr. Birchall had received.
Okay. $3.3 million.
It was 3.3. The judgment ended up being 2.7, and it had nothing to do with interest. Until we get to the supplement.
What's the amount of the judgment today?
It's, Your Honor, approximately, it's in my brief, it's like $1.3 million plus interest and costs.
I know. What's the interest?
I could give an estimate. I would say it's somewhere in the vicinity of $2.2 million.
So we've got 1.3 principal, $2.2 million in interest.
Oh, it would be 2.2 in total.
Yeah, the $3.3 million is the amount of money that she gave him?
Yes.
Back in the 1990s?
Yes.
Okay.
And has there been a hearing as to his ability to pay since May of 2007?
We have had a hearing once or twice a month since that time, at which Mr. Birchall has offered no evidence that he has no money. He has not demonstrated anything other than protesting that he can't pay it, which I would suggest to the court where we have collected the $1.5 million that he was trying to conceal, and they're on the tapes at page 111 of my appendix. There are phone calls there. This was evidence before the court.
One of the problems with that is I've looked at that material. There was a hearing in July of 2008, right? That was a full hearing?
Yes.
Presumably on whether he had ability to pay?
No. That hearing, Your Honor, was initiated by my client because Mr. Birchall was actually the day that the judgment was rendered, he was on the telephone and executed a request. He started to transfer money out of the Swiss account from jail. And if you go to page 139 of the appendix, you will see, Your Honor, his handwritten letter to Swiss partners, and it's dated May 11th of 2007. He started accessing the money, and the money ended up getting transferred into his friend's Florida business account. It was a person who was a resident of Florida and Massachusetts who were able to depose them and get the records. And then from there on, he had it dispersed right under our noses to various people. What the court declined to do was enter a separate finding of contempt, but affirmed its original finding that Mr. Birchall has the ability to pay this judgment.
How much was dispersed under your noses?
Like $27,000.
Oh.
Well, what had happened...
That was dispersed long before you were able to collect the $1.5 million. And as best I can tell, at this July 21, 2008 hearing, there is no evidence, really, of any disbursements or any assets after you were able to collect the $1.5 million.
Everything, Your Honor, we have collected in this case has been discovered by listening to the telephone calls and Mr. Birchall's directives to third parties.
I understand. So is the way this case plays out is every month he's brought in and he's asked, "You paying the money yet?" He says no. Then you listen to the tape recordings of his telephone conversations for the next month to see if you find any clue? I mean, doesn't there have to be more of an examination after 2 years of what his assets, whether he has any assets at all?
Well, Your Honor, I would say if you turn the page over to the domestic relations side, where there is a finding that someone has the ability to pay child support, for instance. In order to have a child support order reduced, you must show that there has been a substantial and material change of circumstances.
You got $1.5 million?
He hasn't demonstrated any change in his circumstances. His position from the day of his initial examination has not changed.
He said he had nothing.
Correct.
You found $1.5 million.
Yes.
You've got it. He's given you a power of attorney, an assignment of all his assets anywhere in the world. You've been unable to find any assets, although you've traveled to places. Isn't it time for a reassessment after 2 years?
No, Your Honor. And I would say this. The statement by my brother that we have traveled the world is something that Mr. Birchall and he have surmised. We have certainly used that assignment, which was not court-ordered, and we have certainly attached his interest in an estate that happened after the execution of that. Mr. Birchall orchestrated a suit out in Western Massachusetts to try to defeat us from collecting on that. I would say this, that the court needs to understand Mr. Birchall's business was concealing assets. It is very difficult, especially under the international banking laws, to find out the names of beneficiaries of trusts. And, Your Honor, if you go to my appendix, I'm going to direct your attention to some evidence in this case, specifically the Swiss bank account, one of which I could only give a sample of some of the evidence that was before the court. And his signature is on a Swiss bank account of Julius Bayer, February of 2007 on page 132 of the appendix. You see he's written a letter to...
Ms. Vecchi, I hate to interrupt you, but you are way over your time. I know you were responding to questions from the justices, and that's fine, but we're now getting into further argument.
Thank you.
If there are no further questions, thank you.